now we're going to switch gears and move over to our question and answer time period for the seminar today. As of right now, we have about 29 questions, which is a good number of questions. So we're just going to start and go very quickly through each question. The first question is, what kind of difficulty or ease would it be for a housing cooperative to become an HOA? What laws would apply and need to be understood? Okay, so this is kind of a complex question. I'm going to simplify it. So it would be very difficult. You would need to have every owner in the association, agree to change, to be part of a planned community or a condominium, depending on how you set it up. And we would have to have in a cooperative, the nonprofit cooperative owns all the land, and the people that live there have like a lease with the cooperative. So it's just a totally different concept. It would be difficult and it would be expensive to do. The way that you would, determine which laws apply to you would be that, you'd have to amend the CC&Rs for the association. You may want to reach out to our firm on this because there may be a way to, handle this. If you want your association to be following laws similar to what Condominium Act has, you might just be able to amend the lease to include a lot of these provisions so that both sides, the cooperative and the owners, are contractually obligated to, live up to the terms of the lease. Okay, question 2. Do you believe that the existing open meeting laws, specifically Section 1, and the use of the word consideration and the public policy statement allow any board to take any action or vote in a legitimate closed session? If so, why? Okay, so I do believe that associations can take action, legal action, in a executive session if they're talking about executive session topics. I think that's the caveat that I would make. So, consideration, I understand where you're going on that. You think that means that you can't vote, but it doesn't say discussion, it says consideration. And I think consideration, indicates that they can vote on the issue. Now, why I say that you can't vote, hire or fire a vendor in executive session is because it doesn't give us that exception. In there, it just says that we can talk about the job performance. It doesn't say that we can fire or hire, under one of the exceptions. So, short answer is I do believe that the board can take action in a closed session, like, telling the attorney to file a foreclosure or, make a decision to settle a lawsuit based upon the attorney's advice. I do feel that can be done during executive session. Okay, question number 3. Can the association limit all flagpoles to a height of 20 feet? Or must the association allow any flagpole that does not exceed the height of the relevant home's roof peak? If it's the roof peak that peaks, then our homes have up to 4 to 5 peaks. Okay, so I think we just have to go to whatever the highest part of the rooftop is on the home, and that's the highest that the flagpole can be. Because under Arizona Revised 33-1808B, we may limit the height of the flagpole to not more than the height of the rooftop of the member's home. So whatever the highest point is, that would be, where you can limit it. I wouldn't do it as a feet thing, 20 feet, because you may have the highest point. The height of the rooftop, highest point may be more than that. Okay, next question. Who regulates HOAs? Good question. Nobody. In Arizona, there is no regulatory agency or ombudsman that regulates HOAs or management companies. The only regulation that's out there is, if somebody is unhappy or aggrieved by what's going on in their board or their association, they can file a lawsuit. They can go to the Arizona Department of Real Estate and file a complaint and have a hearing in front of an administrative law judge. They can remove their board from office. We talked about the removal petition here today. That person can run for the board themselves that's unhappy, or that person can move. But there is no state agency or ombudsman currently that regulates HOAs or that regulates management companies that manage HOAs and condominiums. Okay, next question. If sometimes it sometimes happens that a member comments and evolve into extensive and occasionally combative monologues, what is a reasonable time limit on individual member comments? And to what extent, if any, should a summary of such comments be included in board meeting minutes? So, great question. So, how long should we give owners to talk or members to talk during board meetings at the appropriate time? Which remember, we said that members are allowed to talk before the board takes formal action on something. I think 1 minute or 2 minutes is plenty of time. And if you're having a problem with owners, going on and on and on and getting, everybody starting to fight, put a shorter time limit on how long, the owners can contribute during the meeting. Um, you know, that should be done at the beginning of the meeting and just announce the rules. And this is how, owner feedback or owner comments is going to be handled. Um, I think a reasonable time limit, I like a minute just because I think you can get out what you need to say in a minute. Maybe 2 minutes if you feel that's a little too aggressive. Um, I would say that the meeting minutes, in my opinion, should only reflect what was decided by the board, and it shouldn't be an ongoing narrative of what everybody said at the meeting. So our cheat sheet on board meetings has a great, it's called How to Take Perfectly Proper Meeting Minutes. You could take a look at that. That's on the website at mulcahylawfirm.com, and it says exactly what should be contained in the minutes. But again, minutes should be one page and they should reflect the decisions of the board. So motions, seconds, discussion, just say that the board discussed the issue. You don't have to say what everybody said. And then here's the final vote. Okay, next question. Can our HOA restrict through our rules and regs dogs such as height, weight, and breed? We have a great blog on breed restrictions that we're going to be sharing with you here right now. I guess it's kind of a hard question for me to answer without, seeing your CC&Rs and seeing how broad your rulemaking authority is in your CC&Rs or bylaws. But generally speaking, I would say no, because this is a use restriction and this would need to be in the CC&Rs. So based upon the limited information I have, this is something that I would push to the CC&Rs if you want to enforce it and win if it's challenged by a dog. Question 7, do you recommend recording board meetings and posting them to the HOA website? I've seen concerns about this from HOA association websites. So I'm neutral on recording board meetings. So I would say, probably over half of our clients are now recording their Zoom meetings, and they are placing those recordings in a password protected area of their website. I really don't see any problem with that. Of course, the meeting minutes are still the official record of what is decided at an open board meeting. But some people want to see the actual meeting, and I don't have a problem with that. Putting it on a non-password protected website, that might be something that I would advise against, because anyone from the general public can see it, and I would advise against that. Let's see. Next question, number 8. Under House Bill 2298, if our HOA holds the mandatory vote this year, do we have to wait until 2025 to implement the result of the vote, or can we implement it as soon as the vote is over? Okay, really great question. I'm going to go back up and look at the exact language of that statute to analyze that a little bit further. Okay, so first you have to be a planned community for this law to apply to you. And remember that this law hasn't actually gone into effect yet. So please don't take any action until the law has actually gone into effect, which will be 91 days after the legislature closes. So if you're a planned community and it's after the law has gone into effect and your streets are dedicated to the public, so you're wondering, let's see, not later, shall call meeting of the membership. So if you vote to retain the authority to regulate those public roadways, and you record in the office of the county recorder that, you're going to continue to regulate the public roadways. I think as soon as you do that, that's fine. If the vote fails, let's see, it says if the vote prescribed by this other section fails, or if the plan community does not hold the vote of the membership by, the date here, June 30th, 2025, to vote to, not regulate the roadways, parking on the roadways that are dedicated to the street, the plan community no longer has authority to regulate. So my feeling is once you vote on it, if it fails, you can stop regulating the parking on the roadways from that date, the next date forward. If your board doesn't do anything, doesn't take a vote, then you'd have to wait until after, till July 1st, 2025 to stop regulating the roadways. I hope that answers your question. Okay, let's go back to the next question, which is going to be, I think, question number 9. Our HOA maintains, per the CC&Rs, bare walls insurance coverage. Will we now need to provide 80% of the replacement cost coverage? So let's go back up there and look at that statute, the new statute. Now, again, remember that until the legislature closes, add 91 days until this law goes into effect. So if your policy is coming up for renewal right now, and the new legislation hasn't gone into effect prior to the renewal date, this law doesn't apply to the next policy that, you sign for a year or whatever, however long you sign it. And then when you have the new policy, then it would apply. So let's see. The total amount of insurance after application of any deductible shall not be less than 80% of the actual cash value of the insured property. And so I guess this is a question that you need to push back to your insurance agent. So, is bare walls coverage 80% of the insurable value of your association? It probably is. But I would still push this back to the insurance agent and find out if we have bare walls coverage, are we still in compliance with the 80% requirement that we have here? Now, remember, if it's not bare walls, it's going to be like all inclusive, and that just includes, any improvements that the owner may have made, etc. If it's bare walls, it's, it doesn't include the paint and the, wallpaper or whatever. So I don't think that the 20%, I think that it's not going to change the way that you're doing it, but double check with your insurance agent. Okay, next question, number 10. To amend the bylaws, can this be approved by the board only at a regular open meeting? So I don't know what your bylaws say about amending the documents. Most bylaws require a vote of the membership, and that is a special meeting of the membership to vote to amend bylaws. Occasionally, we do see that the board has the right to amend the bylaws without a vote of the membership. If that's done, it has to be done in an open board meeting. The notice of the meeting must indicate that there's going to be a bylaw amendment, and I would recommend best practices would be tell the people in the notice of the meeting this is what's going to be changed, so that they want to attend and listen, they can. But again, you got to check your bylaws to see what the procedure is to amend the bylaws for your community. Okay, question number 11. Some on our board take a very strict interpretation of rules preventing closed board meetings and believe that using email to discuss issues but not vote is a prohibited thing. I feel that discussion of issues before our public meeting is essential. What are your thoughts on the use of email by the board? Okay, I guess here's the bottom line. If it's less than a quorum that's discussing issues outside of a board meeting by email, that's fine. Or even meeting, less than a quorum can meet to discuss issues outside of a board meeting. That's fine. But a quorum of the board making decisions via email in non-emergency circumstances is a violation of the open meeting law. Now, I would be lying if I didn't tell you that almost every board is probably violating the open meeting law with these emails right now, because they're sending the email to all board members. They're replying all, they're discussing things outside of a board meeting. Just be really careful if you're doing that, because there's no paper trail of the decisions. and the discussions. And if you're already discussing it coming into a board meeting, it's fishy. And owners will start to ask questions. Well, how could you, this really difficult topic, how can we just come into the board meeting and there's no discussion and you just know how you're going to vote? It's fishy. And really, the intent of the law is to have discussion by a quorum of the board in an open board meeting, discussion and vote. Now, obviously, earlier in the presentation, we talked about the exceptions for the emergency meetings, and that is okay to use email in emergency circumstances. If you do make a decision by email and it's as a board and it's not an emergency, what I recommend that you do is immediately fix it at the next board meeting and reaffirm the decision in the meeting minutes so that there's a paper trail and record that the board made this decision in an open board meeting. But really do your best to try to avoid, violating the open meeting law in this way. And we have a great cheat sheet for you on technology and community associations and a blog on this topic too, I think, or I think it's just a cheat sheet actually, which we encourage you to take a look at it if you want more information on this. Okay, next question. Number 12, one of our board of directors called a board meeting and put in the notice that the only people that can speak at the meeting are the ones he gives permission to speak. He can't do that, right? I love these questions because it's always makes me laugh. Okay, obviously you've got some problems at your association, right? And I'm sorry to hear that. But the board member cannot say only you, if you're an owner, and not another owner can talk at a board meeting. All owners have a right to attend, listen, and participate, meaning contribute, um, during a board meeting at appropriate times. So, no, that's not allowable to say that only people that he gives permission to speak can talk. Now, I want to defend this person. I don't even know who this person is, I have no idea. But if people are trying to interrupt the meeting when the board is not taking a formal vote on something, absolutely, the board member can say, no comments from homeowners during this time. But that person should be fair. If they're letting one person talk, they really, need to open it up to everybody. Okay, next question. Is an annual financial report required at an annual meeting? Um, you know, Technically, no. If unless your bylaws would require you to give a financial report. But best practices would be, and every annual meeting that I go to, and every annual meeting that I've ever gone to over the past, 28 years, we see the financial report given to members. Because remember, this is the membership meeting, the annual meeting of the members. And it's our time as a board to give updates about what's going on in the community, about challenges, about successes, about goals, about where we are financially. And so it's a really important and integral part of the discussion at the annual meeting so that we give a good 360 view of what's going on in the community to the owners. If somebody is not giving a financial report at the annual meeting, that would raise significant concerns to me. Like, what are they hiding? Why are we not talking about this? This is an important issue for our community. Okay, next question, number 14. The board adopted new landscape design guidelines and recorded these by unanimous consent. It was stated in the meeting that these were to combat the lots with zero plantings. They mailed out an unreasonable amount of violation notices. I believe the board gave the management company incorrect advice and will lead to a lawsuit. How can a lawsuit be avoided? Okay, the best way to avoid a lawsuit on this is to have the board discuss the landscape design guidelines at an upcoming board meeting and reaffirm the vote. That's the safest and best way to handle it. And I kind of doubt that there's going to be a lawsuit on this, but that's the safest way to do it. So if they're trying to enforce, the lots with the zero plantings, those violations, I would stop enforcing them until you get those design guidelines approved at an open board meeting. Okay, next question, and then I would start over the process. I would probably waive any fines that you have, prior to that for sending out those violations, and I would start over fresh once the landscape design guidelines have been, formally approved by the board at an open board meeting. Okay, next question, number 15. We have a renter that uses the tennis courts for tennis lessons. He has mentioned he charges $70 an hour. We see parents pick up and drop off athletes. The management company says there's nothing they can do because they cannot prove he is giving lessons. We are concerned with the liability issue if someone gets hurt. For other amenities and events, we charge. Do we have any recourse to prevent tennis lessons? And so, yes, I think you definitely, I'm a tennis player, and we have tennis courts at my association, and we have a whole procedure if someone wants to give lessons at the tennis courts at my association. So, number one, I would, you know, call the renter, talk to the renter, have somebody reach out to the renter to find out, or go down to the tennis courts and talk to the renter and find out if they, in fact, are using the tennis courts for lessons. If the renter denies it, then you may need to escalate this to the owner, because there's some liability for the owner too here. If the tenant is, potentially going to be sued, so could the owner if somebody gets hurt at the tennis courts in one of these lessons. The bottom line is you could pass a rule, saying that the board, you'll have to look at your rulemaking authority, but maybe no tennis lessons can be given. No monetary exchange. Maybe you limit the number of guests a person can have in a day. I mean, there's all kinds of ways to combat this. Maybe you allow the renter to give lessons there, but you require that they give the association a percentage of the amounts that they're collecting. And you require that the tennis instructor provide insurance. Most tennis instructors are licensed through the United States Professional Tennis Association. There's an insurance policy that they can get with that, and that would maybe, counter some of the worries about liability. But again, this isn't something that you can't do anything about. No, there's lots of things you can do on this. And if you reach out to me, I can help you manage this issue. Okay, question 16. It looks like we've got 36 questions this morning, so we're moving right along. Do non-scheduled or irregular committee meetings, such as architectural landscape, need to be noticed to the owners in support of the open meeting requirements? So no, if it's not a regularly scheduled committee meeting, under the law, you don't have to. You can if you want to, but you are not legally required to do that. Question 17, can two people take one board position that has become open due to a board member resigning? The two people would only have one vote on the board. So you can't have two people sharing a board position. It's one person can, be on the board. I have seen situations where like a certain board member leaves in the summer and they want another person to come in and take over their board responsibilities. That can be done by the one board member resigning and then the remaining board members appointing the other board member to that spot. And then if flip it back the other way, if that other board member wants to come back on the board, then the newly appointed board member resigns and then the board appoints the other board member. So it can be done, but you can't share board positions. Okay, number 18, can a committee vote on a decision by email outside of a called open committee meeting? This is really kind of a sticky wicket. We have a cheat sheet on committee basics, which I would encourage you to take a look at, and we're going to be sharing that with you. I don't know if this committee is a regularly scheduled committee where they have regularly scheduled meetings. If it is, it's subject to the open meeting law and it needs to be done. All the voting needs to be done in an open board meeting. If it's not a regularly scheduled, committee meeting, then it's arguable that, maybe these decisions can be made by email. A word of caution that I'm going to give you. If you are an architectural committee and you're making decisions via email and you're not meeting regularly, recognize that if you're dealing with a controversial topic, meaning like an approval to make a third story on a house or, I don't know, paint the house, Phoenix Suns purple and orange, something like that, that's going to cause people to get upset and possibly file a lawsuit, you should choose to make that meeting an open meeting. because we want to have every possible T crossed and I dotted. And if you're in that situation, reach out to your legal counsel, reach out to our law firm to help you, because we want you to make your decision completely by the book. And we want you to invite the interested parties and have a good, discussion regarding the application, and then have meeting minutes that reflect what happened, and then a good written, letter with the decision of the architectural committee, et cetera. So if it's going to be challenged and it's not a regularly scheduled committee, I still would make the effort to do it the right way, because we want to win in court if something's challenged. Okay, question number 19. All our governing documents state the board of directors for our association. Our recently elected board used the new title. Our recently elected board of directors instead uses a title to include executive board of directors on all open meeting documents and on emails. I'm aware there is a separate monthly executive meeting for members on sensitive matters, and there are statutes that cover this meeting requirement held by the HOA board of directors. Isn't it misleading to members to retitle the HOA board? I think it is. You want to check to see if the bylaws envision an executive board, or if the CC&Rs envision or mention that. If it doesn't, it is irregular that you would be creating an executive board. And in my experience, how executive boards are typically used is that, let's say you have a 7-person board, they maybe have like an executive board of 3 people or 4 people, and they meet separately away from the board. But it's unusual, and you got to be really careful of the open meeting law, because if the executive board is a quorum, it's a board meeting. So I do think it's misleading to retitle, the name of the HOA board based upon the information you're providing to me. Okay, question 20. 3 of 5 board members accompany an asphalt contractor on an inspection of roads. No decisions are made, and the information will be discussed at the next open board meeting in preparation for a motion and vote on what the board will decide. Does gathering the info constitute a board meeting that has to be noticed? So I guess this is all going to fall on, so 3 of the 5 is going to be a quorum, right? It has to be a quorum of the board discussing association business. So if those 3 are going out with the asphalt contractor and they're not saying anything, which is unlikely, then it's, you're fine. It's not a violation of the open meeting law. But the reality is if you're meeting with the contractor's talking, you're asking questions, and you've got a quorum there, it is an open board meeting. And it should be noticed. Okay, next question, number 21. Should discussion of a fine for a violation be held in executive session? Yes, it can, under enforcement of association documents. Should it be? I mean, it can be. You have a choice. You can either talk about it in the open session, or you can move it to the executive session. I probably, my advice would be talk about it in the executive session. Okay, question 22. When choosing between multiple vendors and then voting on one for a project, is that discussed in an open or executive session? Bid estimates. So when you're thinking about hiring a vendor, and then voting on one, should it be in the open session? I think that should be in the open session, because if you look at the language of the open meeting law, it talks about, you can go into executive session to talk about the job performance of, compensation of, health records of, or complaints against employees of the association, or an individual employee of a contractor of the association. They haven't been hired yet. So that's something that would need to be done in the open session based upon the facts that you've given me here. Okay, so when you're interviewing and when you're deciding on which vendor to use, do that in the open session. Okay, question number 23. It is my understanding that email votes need to be unanimous. Can you please confirm? Okay, we spent a lot of time on this today. We probably need to talk about this in future memos. This is a very good topic because it seems to be a lot of people have questions on it. So you really shouldn't be taking any email votes, because it is contrary or against the open meeting law as a board. Okay. The only exception would be if you have an emergency that needs to be decided, then an email vote can be taken by the board. It could be, it doesn't have to be unanimous. If it's a true emergency, it can be taken, by Zoom, in person, you know, without the 48 hours notice. Okay, next question. But then again, with the emergency meetings, don't forget the next regular board meeting of the association, you have to read into the record what was decided. Okay, number 24, our architectural review is done by board members. No specific meetings are set. We get 1 to 2 requests per month max. We require written approval, email by all the board, and management file records. At a regular board meeting, we just basically present the results. Any problems with conducting business by unanimous email vote? Okay, again, it's the same topic. If you have, even though your architectural committee is, it doesn't sound like you get regular ones, like you have a regular meeting, you're making the decisions by email. Your board is the architectural committee. And anytime a majority of the board is discussing association business, it needs to be an open board meeting. So, what I would recommend that you do is that at your regular board meeting, that you have a time where you talk about architectural requests, because that's, your board handles these requests, and just do it as part of your regular board meeting and include it in the minutes, and stop doing the email votes. If you do an email vote, you should discuss it again and approve it at the regular board meeting, but I really advise against doing that. I think the smartest thing to do is just make it part of your regular board meeting. Okay, question 25. Do architectural request approvals require open meeting approvals, or are written email approvals okay? Okay, so we got 3 in a row questions on this. We kind of have already talked about this topic in depth. If it's a regularly scheduled architectural committee that meets, it doesn't sound like that is here. It we recommend that review architectural requests in an open board meeting. If you don't meet regularly, I guess you can, try to, disapprove them by email. But remember, if somebody challenges it, all of your practices are going to come under scrutiny. And practices would be, does your architectural committee meet regularly? Why didn't you have a meeting? And are there meeting minutes, etc. And so I guess, a lot of associations are doing architectural reviews by email, but when someone challenges it, you really need to dot all your I's and cross all your T's and have a meeting, notice a meeting to be safe, have meeting minutes, have discussion and voting in the meeting minutes. Okay, question number 26 regarding solar panels. Does the community have to ensure the residents' solar panels are operating effectively by removing or trimming trees in the common areas? That's a really good question. I haven't had that one before. So I guess my thought would be, you should be properly trimming your trees as an association, right? And if you have trees that are like hanging on someone's roof, they really should be trimmed back. I don't know, maybe you have some very old trees which provide a shadow or something, and the owner wants you to trim it back so there's no shadow. That may not be a reasonable request. So I'd have to know more about, what's going on here and why the trees are potentially, not allowing the solar panels to operate efficiently. Um, to give you a more formal opinion on that. There could be, a requirement to do that, but it's all based on a reasonable standard. Is it reasonable, that we have to trim it back so only 20% of the tree, has leaves on it? Probably not. Okay, question 27. During an open board meeting, we voted and passed the removal of 2 trees and their stumps. When the contractor came to do the job, our board president changed the work order. He had them leave 1 stump and trim 2 trees instead without prior board input or knowledge. This isn't the first time when the board has voted on an issue and he has made changes. How can we curtail this behavior? Okay, a couple of thoughts that I have on this. Sometimes when you get to the event here, when the contractor came, there's a reason why, we're not going to do something. And so I guess the first thing I would say is reach out to the board member, the board president, and say, why exactly did this get changed, and hear the feedback. And then you're going to have to listen and determine, okay, is that reasonable? Did this exceed the scope of authority that we gave the board president? And if so, what can we do to curb the behavior? I mean, you can always strip the president of his or her title. Typically, under the bylaws, you can take away their presidency. They'll still be a director at large, but that might be something that you do. These are difficult situations because you all need to work together. I would listen to what the president has to say because there might be some facts that we didn't know about when we voted on that, he was informed of. I just know as a board member myself in my community, if I were in that situation and I was a board member on the ground handling a problem, I would make an effort to reach out to the board while it was going on and say, hey, what do you want me to do? Here's some new information. Or if the decision had to be made like record fast time after I made the decision, I would email the board just an update and say, hey, this happened. Don't respond back to me, but I'm just letting you know that this happened today and this is why I did what I did. Let's discuss it at the board meeting next week or next month or whatever. Okay, next question, number 28. Are the transfer or disclosure fees HOA funds or are they management company fees? So, great question. All of this is negotiated in the contract with the management company. So, in my experience, the transfer fees usually go to the association. In my experience, the disclosure fees, the cost for doing the disclosure paperwork as part of the management contract is usually negotiated with the association when they hire the management company. Usually the disclosure fees, not higher than 400 typically go to the management company as per the management contract. But again, all of these things are negotiated as part of the contract with the management company. Okay, question number 29. A member has requested a copy of the materials that the board members get for each regularly scheduled meeting. Can the board refuse to share these materials? So here's how so typically a board gets a packet of information prior to the board meeting, and then you come to the meeting and we discuss the packet. I'm fine with sharing portions of the packet which are, which are able to be disclosed to a member after the meeting. So, for example, if the member wants to see the packet after the board meeting, so the meeting minutes were probably going to be approved at that board meeting. So that's usually the first thing in the packet. They can have those meeting minutes. They can have the financials after the meeting, after they've been approved. They can have, anything in there that isn't privileged, attorney-client privileged, anything that's not pertaining to violations or fines, delinquencies. You'll just have to go through the packet and pull out the things that they're not entitled to have. But they can make that request, and then after the meeting, they can have that packet 10 business days after the meeting. What they can't have is the same packet that the board gets at the meeting and follow along with that packet. That's just the way it works. Because a lot of those things haven't been approved yet, and it's not proper for that to go to a homeowner before the board's had an opportunity to vote on it first. Question number 30. What documents will dictate a change in room rentals for clubs and private parties? Residents have been paying a nominal fee for rentals and charges for setup equipment, etc., and now they want to change that to a per meeting space charge. So I'm assuming you're saying what documents would give the board the authority to do this? Maybe the rules, maybe the CC&Rs. I think I have to see the specific language in your documents. It would be best probably to have something in your CC&Rs, although honestly, I haven't seen very many sets of CC&Rs that envision charges for room rentals, for the clubhouse or whatever. And I don't know how large your association, some of these associations have like ballrooms and, many meeting rooms, etc. And they may have a separate document for their community, which outlines, that you have to join the club or whatever. So it's hard for me to make a comment on this. If you're just a small association and you're trying to get a fee for somebody to rent the clubhouse out, that may be able to be set up in the rules. I have to see how broad the rulemaking authority is. Be careful on this though, because if you're renting it out to the general public, you could be making your place a public accommodation place, and then you'd have to bring your bathrooms and everything up to ADA requirements. So you probably want to talk to your attorney about this as you're navigating this room rental, charges issue. Okay, question number 31. If a homeowner has damaged a community wall due to overwatering on the homeowner's property, what would be the best way for the HOA to address this? I would recommend that the association bring out a contractor to take a look at it and write up a report as to, why the wall is damaged and provide evidence and pictures. And then I would send that evidence from the contractor to the owner with a request to, for them to contribute to fix the wall. Now, of course, I'm assuming that, I don't know what kind of wall this is. So I'm assuming that the wall is on one side, the owner who lives on that side, that they're responsible for that side of the wall, and that the other side of the wall is facing common areas, and that the watering that the owner is doing on their side is now causing damage on our side. Typically in the CC&Rs, when you have a party wall like this, it's outlined in the documents how it's handled. And typically the person that causes the damage is responsible to fix the damage. So just having good documentation from a reputable contractor explaining the damage and how it's being caused, I think is important. And then sending that to the owner with a request, to either pay for the cost to fix it, or for them to have it fixed. Usually you pay the cost and have the association with hire the contractor to fix it. Okay, question number 32. If a homeowner has damaged, let's see, can any one board member ask for an executive session to discuss performance of a contractor? Do we need the majority of the board to agree to have an executive session? So good question. So can any board member, put an agenda item or ask for a special executive session to discuss a contractor's performance? Or do we need a majority of the board? I mean, it just really depends, how this is a tough question to answer because I've seen a lot of different things over 28 years. Sometimes you have like a board member who's fixated on something and it's not a reality. You know what I mean? Like they just dislike a vendor and they want to do anything they can to get rid of the vendor. I mean, of course, I would hear them out. We have an obligation to listen to the board member and their opinion on things. But having a special executive session to discuss it may not be something that the board wants to do. You may want to look at the bylaws to see if one board member can, force an executive session or a regular board meeting. I doubt they can. Usually it's, like 25% of the board or the president can call a meeting. Um, you know, Here, in this situation, I'm guessing what's happening is that a majority of the board doesn't want to have a meeting on this. And so they're using that to say no executive session. So if I were the other board member that wants this, I'd look at the bylaws and see how you can call a special meeting of the board. And if you don't have the votes and you don't have it, just bring it up at a regular board meeting. Okay, question 33. You mentioned that for sale and political sign laws apply to owners' property. Does that also apply to flag displays? So I think I did mention earlier in the session that Arizona law is allowing owners who live in a planned community and a condo to have for sale, for lease, political signs on their property. I'm not sure where you're going on this, but I think maybe you might be saying like our flag displays that are political, can they also have that on their property? So this is kind of a dicey question because, the Arizona legislature hasn't, approved a political flag, as one of their approved flags. So what we did during the 2020 presidential election was we told clients that if somebody wanted to fly a political flag, that we would just recommend to them that the flag not, contain any, swear words or have anything that was offensive to anybody on it, and that they could fly the political flag for the time period that they would be able to have the political sign on their property under the law. So it's just a set period of time before and after the election that they can have it on there. But again, the law is a little bit unclear on this. It's political flags are not listed as a flag that's allowable under the statute. I think my feeling on this back in 2020 when this came up was I don't really want one of my clients to be the case that goes all the way up to the Supreme Court of Arizona on this, because that's going to cost you 300, $400,000 in legal fees to defend. And I don't think you win. I think that this will be, I think the ultimate decision by the court would be that a political flag can be flown under the political sign because they don't define sign specifically. They just talk about the size of the sign, the maximum size of the sign based upon which municipality you live in. So trying to save you a little bit here from spending a lot of money, and I think I would just allow it. Okay, question 34. Townhome community. CC&Rs state no renters. A homeowner has become disabled and cannot climb stairs in their home anymore. Homeowner wants to rent the home due to disability and move to a single story elsewhere. CC&R state there are exceptions such as financial, but no mention of rental exceptions. If we deny their request, would that be against the fair housing law and we could be sued? Oh, this is a good question. I love teaching these classes because you just hear different issues that you hadn't really thought about. Okay, so let's break this down. So the homeowner's disabled, so likely the Fair Housing Act does apply to this situation. They are going to be asking for a reasonable accommodation to the rule regarding, no renters, because they need to move to somewhere else. I mean, it probably does qualify under the Fair Housing Act, and it probably, there are exceptions. You're already saying there are exceptions to this, such as financial. This clearly could be one of the fall under financial, even though it also is a fair housing issue. So I would need to know more, but my initial inclination is you probably do need to make the reasonable accommodation and allow this. Okay, question number 35. In the case of a board recall situation where it does get to the point that a petition has been submitted, you mentioned that it will cost an association at least $5,000. Can you discuss the potential list of charges that could add up? You bet. So the first thing that happens when a recall petition comes in is that we have to verify the names that are listed on the petition. And we do that by checking with, and usually they give it to the attorney for the association right away. And we check each name and we go to the Maricopa County Assessor's Office or the Recorder's Office to see if the person who signed the petition is a record owner. Now, I don't know how large your association is, but sometimes we're, doing 1,000 names. Sometimes it's only 100. Sometimes it's 300. It takes time and it's an hourly rate. And we do, there's a fee for doing this of what our hourly rate is. Well, then let's say that it doesn't move forward. Then we have to write a letter to the people that submitted it saying why it didn't pass. Or if it does move forward, then we have to write the ballot for the meeting. We have to find a location for the meeting. There may be a cost for the location. We have to write a letter to accompany the meeting. There's postage charges for mailing it out, and then also postage charges for the ballot to be returned. Typically, there's a lot of fighting when you get these removal meetings, and there's a lot of back and forth. Sometimes the owners have an attorney, the association always has an attorney. Frequently, there's letters going back and forth fighting about things. Then you get to the actual meeting night, or then you get to the lead up to the meeting. Typically, the day of the meeting, we count all of the ballots in advance, make sure that each ballot is submitted by a record owner by checking to make sure that their person that's listed on the ballot is actually listed on the deed. And then we go to the actual meeting, which is typically kind of short. We follow ballots. Anybody else have to vote? And then we count ballots that came in that night and then announce the results. And then typically we prepare a letter after the meeting explaining what happened and what this means for the association. Sometimes if the recall is successful, then we have to send out a letter to the candidates letter asking for candidates to run for the open positions. And then we have to have a meeting of the membership sometimes. Other times the board appoints, new board members if less than a quorum was removed. there's just a lot of legal issues that come up with a removal meeting. And typically there is a lot of animosity and fighting between the homeowners and the board members that are being removed. And those situations typically result in the attorney being consulted and, lots of back and forth on it. So that's kind of just a little breakdown. In terms of at least 5,000, it is at least 5,000 for sure. Anytime you get a recall meeting notice. Okay, number 35. In the case of let's see, number 36. Is there any requirement for the board to provide reasonable accommodations to provide meetings in a climate controlled area during the summer? So this raises a fair housing issue. And I don't know if you have a resident that is handicapped that is asking for this. I think there are lots of workarounds on this that wouldn't require you to have it, in an air conditioned spot. I mean, of course, you should consider it just as a courtesy, but this person may be able to appear telephonically or by Zoom, would be a possible way that, we can accommodate them so that if the heat is a factor, I think there's many other ways versus, forcing the association to go into, like a climate controlled area. But I mean, you want to listen to your residents. If everybody wants it to go inside somewhere, I think as a board, you're elected by your constituents. And so you should, carefully consider any requests like this. If there are a large number of people that want this, you may want to consider doing it, or you may just want to switch to Zoom in the hotter months and have your meetings on Zoom. Okay, next question, number 37. Per our documents, our board should have 5 members, but we have been at 4 since the annual meeting in March. There seems to be no urgency to fill the vacancy through posting the need on our webpage, etc. What is the correct way to fill up the board? Are there deadlines we need to abide by? Okay, so it appears your board had 5 members, but then for whatever reason, we after the annual meeting in March, it went down to 4. I mean, it really is up to your board how they handle this. As legal counsel for an association, I would recommend to a board that, you consider trying to fill that 5th vacancy, because if I had to guess, your documents say that the board shall consist of 5 people. But there are many times where we can't get people to volunteer to serve on the board. And it's just not a reality that, we can find somebody to actually be that 5th board member. If your board is doing it because they know that the only people who want to serve on the board are people they don't like, which sometimes, unfortunately, we see, that's really not a good reason. And what I would recommend is that you put some pressure on the board by writing a letter saying, there's a vacancy on the board. I would like to be considered to fill that vacancy if that's what's prompting this question. Or we're asking that you send out a letter to the membership to fill the vacancy, ask people for volunteers to fill a vacancy and see what they do. Okay, we got through 37 questions and we still have 3 minutes left. It's 12:57, so we're making great time today. Today we had 144 live viewers on Zoom. I think that might be one of our highest ones other than during the pandemic when everybody was at home and everybody was logging on. And we had many others joining us on Facebook Live today. So thank you so much for being here today to make your communities better and to learn more about Arizona law regarding HOAs and condos. One little thing that I want to remind you about is that we are not having a first Friday in July due to the 4th of July holiday week. So our next virtual First Friday event is going to be Friday, August 4th at 9 a.m. So no first Friday, the first Friday in July. Don't forget that next month in July, we're going to be teaching class number 7 of our Virtual HOA Academy on July 18th at 11 a.m. And the topic for this class is going to be understanding the hierarchy of association documents. And we're going to talk about a 5-step plan for how to amend your CC&Rs. And then also we're going to spend a little bit of time talking about records requests and, how to best handle them when difficulties arise with owners wanting to see records. And so we hope that you'll join us on Tuesday, July 18th to talk about these topics. Lastly, I'm just going to make a little ask here at the end of my presentation here today. I'm asking, if you're inclined to do so, to please consider leaving our firm a Google review for teaching these classes. We're going to share a link in the chat on how to leave a review. So you'll be seeing that on your screen here if you're joining us on Zoom or Facebook Live. We put a lot of time and effort into preparing these classes, and we are interested in hearing feedback from you so that we can share those with the cities that we partner with about whether you think these classes are valuable, about whether you think we're efficiently using the time, about whether we're answering all of your questions, any topics that you'd like to hear us talk about in the future. Please consider leaving us a Google review. It's really important that we get your feedback so that we continue these classes going forward. So we're going to be sharing that Google review link with you shortly. And I ask you, please, if you're inclined to do so, to go ahead and do that today. Thank you again to all the neighborhood services departments that we partner with to teach these classes. We appreciate you caring about your residents and your owners, and making sure that your communities are healthy and following the laws. Thank you again to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. We've enjoyed working with you to teach these classes and to bring this educational content to the residents of Arizona, to help them better run their associations. And we appreciate the opportunity to work with you. So thank you again, everybody. Have a wonderful 4th of July, my most favorite holiday of the year. Hope you have a great time with your family and friends. And I look forward to seeing you again on July 18th. Take care, everybody. Bye.